I'd just like to start off by saying thank you very much for the invite from the Bassa branch to come down here today. I didn't mind at all getting up at about 4:30 this morning. I think it's very worthwhile. And I did come by train, just to make it clear. I did look into coming down by BA, but I thought, they might not like it. So I just want to say, actually, put on the record, I'm very, very grateful for the opportunity to come down and speak, as I'm sure Ralph is as well. And I think one of the reasons why we're so grateful is not just about coming here and supporting yourself in your struggle, but it's also because as academics who study industrial relations and study unions, it's also very important for us to come and, as it were, meet the people that we're studying, to be able to communicate with them and engage with them, because it's very easy to, if you like, just study things from afar. It's very good to be able to come and actually see people, speak to them. So thanks again for that. Now, I want to focus basically in the time that I have available to me in terms of the issues of the right to strike. But just before I get there, I want to say that it's my opinion, my academic opinion from the expertise and the research that I've done, that you are engaged in a war of attrition. I think what Willie Walsh and BA are counting on is by the end of the last 5 days of strike action next week, you are so ground down, so demoralised, so tired, so penniless. I think the strategy on BA's part is they hope you will capitulate. And I think the evidence here today from you and from your colleagues elsewhere is that's not going to happen. That collective power and determination that you will be able to face down the company and have the prospect of winning this dispute and winning it on your terms. So, in that sense, best of luck to you, because it is a struggle about union busting, and it is, as Ralph has already said, a struggle about the race to the bottom. You have hard-won terms and conditions, and there's absolutely nothing wrong in this world with trying to defend them. In fact, if you do defend them, you're also doing a service to other people, because as Ralph has already highlighted, if you lose this dispute, it's going to be that much easier for other employers to say, well, they accepted it, they couldn't win it, and some other group of workers is next. So what I'm about to say, in some ways may surprise you, in some ways may not. In Britain, in 2010, and it has been the case for over a century, there is no positive right to strike. Okay? What I mean by that is there is no piece of legislation, there is no constitution, there is no act of parliament that says that you have a free and positive, unrestrained right to strike. What we have in this country, which is a scandal and it's an anomaly, is that unions in this country have immunity from tort. And what that means is immunity from prosecution for loss of business. And it goes all the way back to the Taft Vale case in the early part of the 19th century. And in 1906 there was the Trade Disputes Act, which introduced this, what's called a legal privilege. So unlike your fellow cabin crew and your fellow airline workers in other countries, like France, like Germany, there are actually no legal right to strike in Britain. As I say, it's just this thing, this legal privilege, that unions have the right not to be prosecuted for loss of business. And while that's important, it still means, subject to the law about the 12 weeks thing, that actually you can be sacked for going on a legitimate strike. And that clearly is an absolute travesty for a modern society, for Britain in the 21st century. And I think that's one of the things that you need to be able to kind of draw out of this dispute. Yes, you need to work towards resolving this dispute in your favour, but I hope also that in the course of this dispute, your ears are going to be pricked up about the lack of justice for workers in Britain in 21st century Britain. So let me just say a few things about this. Looking at your ages, without wishing to offend any of you, I think that most of you will remember the 1980s. Most of you will remember the Thatcher governments. And you will remember that there were a series of anti-union laws introduced really about every 2 years in the 1980s. And what they did was they narrowed this immunity, this legal immunity, so that now it's very, very difficult to have a strike. You're not allowed to have solidarity action. If you go back to the Gate Gourmet case in 2005, that action that was taken by some of your co-workers in support of the Gate Gourmet workers was unlawful. Now, why should that be the case? Why is it that employers are allowed to aggregate their resources, their wealth together, in order to defeat unions, in order to drive down wages and conditions of workers, but you as workers are not allowed to stand together? there's something clearly wrong about that situation. It's also the case in picketing terms. You're only lawfully allowed 6 pickets. Why is it that, you know, a company can pay more money to some people to go through and take supplies or take things out of a factory, but you are not allowed to have more than 6 pickets? And clearly with 6 pickets you're not going to do that much, are you? You're not going to be able necessarily to stop the goods going in or the services coming out or whatever it is. And also blacking, that is not wanting to work with non-union members or scab members, that's illegal as well. So what I'm coming to the point is that all the laws, and it's, you know, this is the sense in which it's a great tribute to you to have stuck together for so long, when all the laws are stacked against you. And all the laws in Britain in regard to strikes and industrial action, it's a funny situation because Britain, all the governments in Britain throughout the years have signed the International Labour Organisation Declarations and Convention, they've signed the Council of Europe declarations, they've signed the United Nations declarations, but they do not enforce them. Because if they did enforce them, you would have the right to call on your brothers and sisters and the rest of British Airways to come out and support you. You would have the right to have mass pickets to stop other crew going in. You would have all these things. And I tell you, with those laws, if they were in place, I don't think we'd be standing here today. I think you'd be back at work with a smile on your face because you had won this strike. So the lesson that I draw from this is that the reason why Thatcher and her cohorts brought in these laws, and the reason why Tony Blair and others didn't change them when they came into power in 1997 is that they obviously agree with them, but more than that, they agree with the employers. I think it's right that the employers have all these rights to do these things, to stop workers being able to act collectively together, and they think it's right that the employers should be able to pursue profit, you know, without regard to what that means for the workers. And the reason why they know this, and again I'm going to kind of turn the clock back in terms of history, the reason why they know this was because in the early 1970s there were mass pickets, there was mass unofficial action, and a piece of legislation called the Industrial Relations Act that was passed by Ted Heath in 1971, that became a dead letter because of resistance from workers. There was 5 dockers who were jailed in Pentonville Jail in London, and essentially they and the campaign behind them broke that law. And I think this is what we're facing in terms of the new politics. The new politics is something that Cameron and Clegg talk about, but we need our own new politics, which is about saying we will not accept these laws anymore, we will defy them. And that's what it's come to. Because despite the fact that we've had a new Labour government for 13 years, those laws have remained in place. And I want to finish on this point. Your Joint General Secretary Tony Woodley was absolutely correct to excoriate and criticise New Labour when he spoke at your policy conference up in Manchester on Monday. That's good, that's necessary, but it's not sufficient. Because if you believe in those words, you must take the step that follows that. And that step that follows it is to do something about that. And I think, as I say, it's come to a point where if you are back in the High Court because BA has found another way to challenge your strike, it's going to come down to the issue of defiance. Not just challenging the law in the court and hopefully winning, but defying the injunctions. And saying to the law, 2 fingers, we are going to do what is necessary and what it takes to win this dispute. So I hope that you do learn those lessons. I don't mean to be at all patronising or to talk down to you, but I hope that you do learn those lessons and that you don't forget them when this dispute's over, and you talk to your family and your friends and your other union members, and we can actually build a movement that's capable of creating justice in 21st century Britain. Thank you.